Today's discussion is a bit different from the topics which we have covered in this program before, as I will be exploring how to create a valid will. Now, before I delve into this discussion, I will first define what is meant by a standard will, and then I will give you some basic reasons as to why persons prepare a will before their death. Essentially, a standard will is a revocable declaration that is made by someone in contemplation of their death, in which that person expresses their intentions regarding matters which intend to take effect after their death. What this basically means is that a will is a legal document that someone prepares to let them decide what happens to their estate after their death. So, some of the basic reasons that people would create a will include to determine who will manage your estate, or to choose who to give your property to, or ultimately who not to give it to. You can decide how to take care of your minor children or who will take care of your minor children. You can provide funeral arrangements, or ultimately, you can lessen the chances of your family fighting over your property after you die. In Guyana, for a standard will to be valid and consequently admitted to probate, there are three requirements which are needed. It must be made by a person who has attained the age of majority. It must be made in compliance with the formal statutory requirements, which is the Wills Act of Guyana, Chapter 1202. And the person making the will, who is called a testator or a testatrix, must have testamentary capacity, or what is referred to as the animus testandi, to make that will. So today I will be focusing on some of the statutory requirements in preparing a will, in which I will reference the Wills Act throughout. So firstly, the form of the will. The will must be in writing as required by Section 4 of the Act. Now, this does not mean that a will must be in the handwriting of the testator. In fact, it can be handwritten, it can be typed, it can be a mixture of both handwritten and typed. Ultimately, the will must not be an oral declaration, but it must be written. The signature of the testator. So the will must be signed by the testator, as also required by Section 4 of the Wills Act. So at this juncture, we must ask ourselves, what constitutes a signature? So this question has been interpreted quite liberally by the courts, in which cases state that the testator must put some mark on the document which he intends to be his signature. So the testator can put a thumbprint, he can put initials, he can put a stamp, all of which he intends to be his will. So the important fact is whatever mark the testator puts, he must intend that mark to be his will. The will can also be signed by someone else in the testator's presence and under his direction, which is also stipulated by Section 4 of the Act. Now, this is done in cases where the testator is visually impaired, where he's suffering from illnesses that precludes him from writing, or where he's just physically incapable or illiterate, but the person signing can either sign his name or the testator's name. So while the legislation does not require a specific form of attestation, in cases where the testator has not signed, that person should prepare a special attestation clause. Now, this clause would state that the will was not signed by the testator. It was signed by someone else under his direction and in his presence. It must also state the reason why the testator did not sign. Let's say the testator is visually impaired, or at that time, the testator was unwell. And it must also state that the will was read over to the testator and he appeared to understand its contents. Now, it is advisable to include this special attestation clause. Why? Because it prevents problems or future litigation. For instance, if before your death, the testator usually signs his documents, and then after his death, his family realizes there's a will, and that will was signed by someone else. Now, if there's no attestation clause, the family members may think that the will is fraudulent, and they may challenge the validity. So it's advisable to include this clause to avoid all of these later problems. Now, alternatively, Section 4 of the Wills Act actually allows the testator to acknowledge a previously written signature to his witnesses. This means that it's sufficient for the testator to merely ask a witness to sign the documentation, so long as they can see or have the opportunity to see his signature in that document. Now, a valid acknowledgement then basically means that the will must have already been signed by the testator and the witnesses could see or have the opportunity to see that signature. So I will now address the placement of the testator's signature. According to Section 5 of the Act, if the testator's signature appears at, after, following, under, beside, or opposite the end of the will, then the entire will is regarded as valid. The intention of the testator is paramount. Emphasis is placed on when and not where he places his signature. In practice, the testator's signature is usually placed at the end of the document. Okay, so now I'll focus on the witnesses of the will. So Section 4 of the Wills Act allows for the testator to sign the will in the presence of 2 or more witnesses. So you can have 2 witnesses, 4 witnesses, however, both of them must be present at the same time. So firstly, the testator will sign or acknowledge his signature in the presence of both of them, and then those 2 witnesses will in turn sign the will. The legislation does not provide for any specific position of the witness's signature. However, the signature must or is usually found after the testator's signature. As it relates to the competence of the witnesses, Section 6 of the Act allows for anyone who is above the age of 14 competent to give evidence in any court of Guyana to also attest to a will. Some key points to note on choosing a witness. So I'll first look at gifts to a witness. So the person who benefits under a will by receiving any property is known as a beneficiary. So Section 7 of the Wills Act actually allows for any person that you give a gift to who is also a witness, that gift will be null and void. So what this means is essentially that if you have a beneficiary in your will, you should not ask that person to also be a witness to your will, because they will no longer benefit from the property. While the will remain valid, they will not benefit from the property. So as it relates to an executor as a witness, so in a will, the testator usually appoints somebody to look after or manage or administer his or her estate, and that person is known as the executor or the executrix. So in choosing a witness, Section 8 provides that if anybody attests to the will is also appointed as the executor, the appointment of executor will be deemed as null and void. This simply means that the person you choose as your executor should not also be the person you're choosing to sign as a witness to your will. So essentially, you should be mindful of who you choose to act as your witnesses to the will. So considering the brief discussion above, it must be remembered that if some or all of these preconditions are not met, the will that is prepared and presented to the court may be deemed as invalid and it will not be admitted to probate. And even if after the death of a testator, the family members looking through the will notice many inconsistencies or discrepancies, they too can challenge the validity of this will on some or all of the grounds as were mentioned above. On the next occasion, I will briefly address some of the contents that are usually included in a will, as well as how to apply for a grant of probate and a grant of letters of administration. Until next time, thank you.
Audio Jungle.